Welcome back to another session of Dispute Resolution by SQE1 window. We'll try to cover alternate dispute resolution today in this session. So, alternate dispute resolution, as it says, it is alternate to litigation that courts in England and Wales, they love you once you can resolve it on your own as a responsible child of law. So at that point, imagine resolving dispute without courtroom theatrics, no wigs, no dramatic pauses, and definitely no one snoring at the back. That's ADR, that is DIY, that you do things, you resolve things on your own. It's now fully part of civil justice system in England and Wales, and courts actively encourage it. Refusing ADR unreasonably, and even if you win, you could still face cost of sanction. You need to pay for other party at some point, like once you refused ADR. So do not do that, but do that don't be like that person who politely declines and then complains about the legal bills later. So the main benefit, you save money, you save time, you keep relationship intact, and you get flexibility and confidentiality, all benefits of ADR. In short, ADR lets you have your cake and eat it too without paying the litigation bakery prices. So be responsible, kid. So what are the benefits of ADR? So why we should choose ADR? First, it's cheaper and faster. Settlement can happen in days or weeks instead of months or even years in court. Second, it gives a neutral, non-threatening environment where you can calmly reflect on your position rather than gearing up the battle. ADR is flexible. Outcome can be bespoke contracts. You can have a new contract, agreeable contract, ongoing business arrangement without falling apart, or quirky non-monetary solutions in some cases. And on the top, you got for confidentiality. That is a huge plus. It protects sensitive information and helps preserve business relationship. That's what is the purpose of commercial or civil law. And here is a sneaky bonus. ADR gives insight into opponent thinking. It's like being Sherlock Holmes, but without the dear stalker hat. And remember, for SQE1, ADR isn't just about saving money, it is about strategy and creative problem solving. And you should be expert in ADR, and you should know other party stance, that what they want out of it. So what is the court role? The courts are not passive on this. They actively promote ADR. Civil Procedure Rule 1.4 and blah 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 explicitly requires it. Court can pause proceeding to let parties attempt ADR, and pre-action protocol require you to consider ADR before you start litigation. Refusing ADR without a good reason, and this might pay the price. This might make you pay the price in court, even if you win. Halsey versus Milton Keynes tells us court will scrutinize whether your refusal was reasonable or not. So there are other cases. Those confirm ignoring an ADR invitation can lead to penalties by the court. Churchill, for example, Churchill's case, not that Churchill. This is another one from 2023, confirms court can order ADR provided it's fair and proportionate for the parties. For SQE1, remember, ADR compliance isn't optional. It can influence both cost and strategy for your client. So another thing, there are different types of ADR. ADR comes in several flavors. First, negotiation, informal, without prejudice, cheap and flexible, pick up your phone and negotiate. Simple like a cup of tea. Then mediation, a neutral facilitator, helps parties reach a voluntary settlement, confidential and non-binding, like barista who keeps both sides calm. Say conciliation is another type of ADR that is similar but more proactive, the conciliator may suggest settlement terms common in employment disputes, it works, and early neutral evaluation. That's important. An independent expert evaluates the merit of case. Think of it as brutally honest and of ADR. She tells you the cold truth, whether you like it or not. Remember, facilitative ADR guides the parties, with evaluative ADR gives reality check that where you are, can you win or not, and it pulls away all your emotions away. So that's what we need to keep in mind in terms of ADR. So the heavyweight ADR, that is expert determination. So yeah, expert determination, at that point we need to understand. So a technical or legal expert resolves issue. It may be binding on or non-binding. Perfect when only a specialist can understand the problem. Adjudication is fast and binding, often used in construction disputes, with decision usually within 28 days. It's very fast. Think of it as speed dating for dispute, just finish it. Finally, arbitration, a binding decision by an arbitrator, enforceable like a court judgment, governed by Arbitration Act 1996. It is confidential but more formal and potentially costly. People want to become arbitrator to make big money after becoming solicitors. SQE1, for SQE1, the understanding should be choose the ADR type depending on speed, complexity, and whether you want a binding outcome out of ADR or not. Another thing is mediation process. We need to understand how it works. Mediation, most of the time it works in civil cases. People go mediate and solve it. A mediator is appointed, and that is voluntary, that you can choose it. And that is partly controlled and facilitated. Preparation is key. Select a mediator, agree a mediation agreement, and submit position statement. These statements are your battle plan, how you will fight. But without the battlefield, it's negative. It's kind of you are trying to resolve the issue. One on the day, once you start it, you shall have joint session, private kind of session, shuttle diplomacy, the mediator running between rooms like a postal worker on a tight schedule. Remember the mediator. Sorry for that. Okay, so sorry for that. So remember that now the mediator or mediation goes online most of the time. The mediator does not decide, the parties retain control. Settlements are recorded in legally binding agreement. Mediation does not just solve legal issue, it addresses underlying commercial concerns and helps preserve relationships. For SQE1, remember this step: preparing, day of process, settlement, and handy notes that you got for mediation. So arbitration is another thing that we need to understand. Arbitration is adjudicative. You submit to an arbitrator who issues a binding award. It's common in contracts with arbitration clauses, construction disputes, and international trade. The advantages: confidentiality, things don't go to court. Expertise and procedural flexibility. It's not like courts, so it's flexible. So what are disadvantages? Cost can be high. Arbitrators, really, they charge a lot, maybe sometime 1% of the dispute. Proceeding may take a while. It's winner takes all kind of thing. Think of arbitration as the posh cousin of mediation: formal, binding, and slightly intimidating. So for SQE, distinguish between arbitration and mediation. So mediation is not binding, arbitration is binding. That's what you need to understand. So how to choose? Consider the nature of dispute, stage, complexity, relationship, and commercial objective. Facilitative ADR, like mediation or conciliation, is ideal for ongoing relationship and negotiated solutions. Adjudicative ADR, like arbitration or expert determination, is better for technical, high value, or complex dispute. Not all cases suit ADR. Sometimes you need injunction, precedent, or summary judgment. ADR is a tool, not a magic wand that helps in everything. For SQE, you need to be careful. Know the differences between ADR and litigation, benefit, risk, and strategic use. Understand types of ADR, suitability, and key procedural features. Recall the case, Halsey, the case and the Churchill's case. Once you don't follow ADR, you need to pay the price. No mediation steps. Usually they don't ask you about the cases, but sometimes they can. So, no, in mediation, you need to prepare day of process and settlement documentation, distinguish facilitative from adjudicative ADR, and recognize the consequences of unreasonable refusal of taking ADR. For you, the exam tip that I got is use mini scenarios and ask yourself whether ADR is suitable or not. For example, a client needs injunction. At that point, you will not wait for mediation and all. You will straight away step to the court to stop a party from doing something. So it all depends on the situation, and you are the boss to decide. Thank you very much for your time. Have a good day. Ta-da.